Good morning, Ya Arif. May it please the court, my name is Mazni Adibah binti Mhd Rahim from Awsam and Co. I appear in this court today on behalf of my clients, Ramesh, son of Arumgum, and Tu Siu Kem. Along with me in this court is my learned counsel, Nur Anis binti Abdullah, and also learned DPP, Hannan Umairah binti Azman Shapawi, and learned DPP Nurul Syuhada Johari. I shall limit my submission to this court of appeal only for 7 minutes and 30 seconds. Ya Arif, my clients were convicted in the High Court of Shah Alam on 20th January 2020 under Section 302, read together with Section 34 of the Penal Code, and they were sentenced to death. It is submitted that on the night of 3rd April 2017, one named Sukumaran, son of Arumgum, was murdered. The prosecution witnesses claimed that the appellants had come to the scene and one of them had slashed the back of the deceased before he ran to the plantation. However, the prosecution witnesses had contradicted each other on who actually slashed the back of the deceased. The appellants, however, denied they brought any weapons to the scene and also attacked the deceased aggressively. They denied they killed the deceased because they also did not know the whereabouts of the deceased when they left the scene. The investigation men also did not find any murder weapon in the possession of the appellants. Here, on behalf of my clients, I appear to appeal on the decision made by the High Court on the conviction and sentence of them for the said offence on 4 grounds. Ya Arif, now I submit the first ground whereby the learned judge erred in finding that the elements of murder under Section 300 of the Penal Code has been established. I beg you to refer to the case of Sanal Abidin bin Madin at page 4, whereby the requirement has been laid down to convict a person under Section 300C. This includes first, the victim died, second, he dies as the result of bodily injuries sustained by him, third, the bodily injuries were caused as the result of the acts of the accused person, and the last one is in inflicting the injuries, the accused person has done it with the intention of so causing such bodily injuries which were sufficient in the recourse of nature to cause death. Ya Arif, the first and second elements cannot be disputed, and on the appellant side also we satisfied with the finding made by the prosecution. However, the third element is the most critical one, because no one saw that the appellants had killed the deceased in the palm plantation. The learned DPP had to rest purely his case on circumstantial evidence. The law on circumstantial evidence is well settled and permissible. However, it is the position of the appellants that the circumstances relied by the prosecution is in this present case is not properly established, and it shall be discussed in the following ground. Ya Arif, now I submit the second ground of the appeal, which is the learned judge erred in holding that the circumstantial evidence was sufficient. The onus on the prosecution where the evidence is of a circumstantial nature is a very heavy one, and the evidence must point irresistibly to the conclusion of the guilt of the accused. If there are gaps in it, then it is not sufficient. This principle has been held in the Federal Court of Kuching in the case of Chang Kim Seong. It is the position of the appellants that the learned judge failed to observe several factors which are substantial in the present case, which only relied on circumstantial evidence. It is submitted, first, the learned judge had failed to observe the concept of last century correctly. It is the position of the appellants that the concept of last century shall not be the conclusive evidence towards the guilt of the accused unless if it was supported with other circumstances. This principle can be referred to the case of public prosecutor and Willy Anaksala. It is submitted that the so-called attack as claimed by the prosecution witnesses happened at about 11:30 p.m. Meanwhile, the body of the deceased was only found in the following morning at about 7:15 a.m. Here, last seen concept arises because the prosecution witnesses saw the appellants to be the last persons emerged from the plantation on the said night after the attacking. However, it is submitted that the 8 hours time gap between the attack and also the body recovered is not small. So this led to a belief that over the night, the author of the crime can be any other person that can cause the death of the deceased, not only direct to the appellants. In the addition to the time gap, it must be noted also it is unsafe to cast guilt on the appellants when no murder weapon found in the possession of the appellants. Above the fact, the learned judge also erred for not emphasizing the fact that both of the appellants have no motive to commit the murder. In the case of Ling Hang Sir and public prosecutor, the court has followed the principle in Ratan Lal, which mentioned that ordinarily, when there is sufficient and direct evidence connecting the accused with the commission of the offence, the proof of motive becomes unimportant. However, where the entire prosecution rests on the circumstantial evidence, motive undoubtedly plays an important part. Ya Arif, it is submitted that after observing the fact that the appellants have no animosity nor resentment towards the deceased, and neither of the prosecution witnesses also mentioned about this fact, so it raises doubt and suspicion on why the appellants have to kill their own friends since childhood without a clear motive. And this fact was failed to be observed by the learned judge. After scrutinizing the whole facts, it is submitted that the circumstantial evidence relied by the prosecution in this present case cannot be said conclusively pointing towards the appellants to be guilty for the murder because of the loophole in this trend of circumstantial evidence. So to sum up, the learned judge had erred in finding that the circumstantial evidence is sufficient to convict the appellants for the murder, and also the third ingredient of murder cannot be established. So coming back to the first ground, the learned judge also erred in finding that the elements of murder under section 300 of the Penal Code has been established. So the appellants then shall not be convicted for the offence of murder and they deserve acquittal. May it please the court, I end my submission, and now I pass the floor to my learned counsel Nur Anis to address the following grounds of appeal. Much obliged, Johari.
May it please the court. My name is Nur Anis binti Abdullah and I am the co-counsel for Mazni Adibah. I intend to deal with the third and fourth ground of appeal. First, for the third ground of appeal, it is submitted that the learned judge had misdirected himself by concluding that the discrepancy of evidence is immaterial and it did not affect the prosecution case. The main contradiction of evidence is pertaining to the different version of events that was narrated by each witness, especially who had slashed the disease that night. SP6 testified that he witnessed that it was the second appellant who slashed the disease at his back. He was positive and firm with his statement. However, in SP12's testimony, he testified that the first appellant was the one who attacked the disease. In addition, both the witnesses stated that they were familiar with each other and recognized the appellants. They grew up in the same neighborhood and were acquaintances. Ya Arif, on behalf of the appellant, we are in our view that the contradiction occurred is material in the light of the crucial issue of the identification of the appellant at the scene, and it raised the question of credibility of SP6 and SP12. It is arguable whether there is a reasonable doubt that they were so culpable. Who was actually telling the truth? Was it SP6 or SP12? By referring to the case of Datuk Seri Anwar Ibrahim against public prosecutor, the court did not accept the finding of the trial judge that a witness was a witness of truth. An appellate court should go further and examine the evidence and the circumstances under which that finding is made. Moreover, in the current case, it is known that the witnesses and the appellants were friends. From this statement, it had caused reasonable doubt on their testimony, as it is unreasonable for them to differ in determining who had slashed the disease that night, as they contended earlier that they were very familiar with the appellants. If a person really knew and was familiar with someone, it is illogical to not recognize them, especially their physical appearance. There is another matter which further weakens the prosecution case. It is irrational for SP6 and SP12 to be different in determining who had / the disease, as the accused person were from different races, which the appearance of an Indian and a Chinese are clearly distinguishable. Therefore, it had caused reasonable doubt in providing evidence. To conclude, the court should not solely depend on the testimony made by the witnesses, as it might be questionable and it creates reasonable doubt in the case. Yang Arif, now I submit the fourth ground of the appeal, which is the learned judge failed to make a finding on common intention between the appellants under Section 34 of the Penal Code. The trial judge found that the appellants arrived in the same car and looking for the disease. After alighting from the same car, they immediately attacked the disease using a knife or parang. Subsequently, the disease ran into the plantation with the appellants in pursuit of him. They leave the scene with the same car they arrived with. It is the clearest and best form of evidence that the court considered in determining the common intention between the accused person. By referring to the case of Ling Hangther against public prosecutor, the law on Section 34 of the Penal Code is well established. The element of Section 34 of the Penal Code stated that it must be a criminal act. Second, there must be participation in doing of the act. Third, there must be a common intention between the parties, and the last is the act must be done in furtherance of the common intention. Yeah, Arif. The charge against the appellants specifically stated that the first appellant and the second appellant in furtherance of common intention was in the commission of murdering the deceased. The defense claims that there was absolutely no evidence to show a meeting of minds and any prearranged plan between both of the appellants to allegedly commit the non-existent murder charge. The learned judge was convinced with the evidence that they arrived and left the crime scene in the same car. Nevertheless, even if the accused person were arriving simultaneously, the act was insufficient to indicate that both of them were having common intention to attack and committing the murder of the deceased. In the case of Nama Siam against public prosecutor, it can be concluded that there was no evidence to prove that the second, third, and fourth accused in that case were present at the scene as confederates of the first accused. Furthermore, it cannot be simply concluded that the appellants were subsequently attacking the deceased while carrying the weapons as the premeditation to commit murder. It was undisputed that to constitute common intention, there must be a prearranged plan. However, based on the circumstantial evidence, it shows that there was no either one of the described weapons found or in possession of the accused person. Therefore, the court cannot abandon the denial by the appellants that they were carrying any weapon nor / the disease. It is undisputed that appellants had chased the disease into the plantation. Nevertheless, the appellants stated that they were not chasing the disease to murder him, but were instead trying to prevent further harm being caused to the disease. To conclude, the element of common intention is not fulfilled as the learned judge failed to determine who had actually / the disease, which is material to ensure that the act was in furtherance of committing a criminal act. The discrepancy of evidence between the witnesses was questionable and had caused reasonable doubt in this case. Having regard to the above grounds of appeal, it is submitted that the learned judge's decision to convict the appellants for the offence under Section 302 of the Penal Code, read together with Section 34, shall be set aside. Further, the appellants deserve acquittal from the death sentence of the conviction. If I may be no further assistance to the court, that concludes my submission.
Good morning. I bid to the Honorable Judge, my fellow friends from the Defense Counsel and the Respondent. My name is Hannan Umairah binti Azman Shapawi. Today, I would like to submit the submission of the case on the part of respondent. Your Honor, today, on behalf of the respondent, we would like to respond on the 4 issues from the appellant, whereby I will submit the 2 issues and my co-counsel will submit the other 2 issues. The 2 issues are whether the ingredients under section 300 of the Penal Code had been established towards the appellant and whether there is a strong and sufficient circumstantial evidence from the court to rely upon in determining the liability of the appellants. Your Honor, if it please the court, I would like to submit my first submission in regards to the first issue by the appellant. I represent the respondent, solely agreed that it is clear that the accused person is guilty of murder based on the analysis of the definition of murder under section 300 subsection C. As referred to the case of Zainal Abidin bin Mading against public prosecutor, there are 4 elements need to be proven in considering the act of murder under section 300C. Your Honor, after scrutinizing of the facts of the case, the first element, the victim died, and the second element, the victim died as the result of bodily injuries sustained by him, was undisputed by the appellant. Therefore, I will move to the third ingredient in regards to the bodily injury that must be the result of the acts of the accused person. In order to prove the third element, the bodily injury must be the result of the acts of the accused person. The court will purely look at the circumstantial evidence produced. This will be explained in my second submission. Your Honor, for the second submission is regarding the third issue, which is the circumstantial evidence is strong and sufficient for the court to rely upon in determining the liability of the appellants. In dealing with the case where it is purely on circumstantial evidence, the evidence established must fulfill certain requirements. According to the case of Magindran Mohan against public prosecutor, the court has referred to the case of Chanmal and another against state of Rajasthan. There are 3 tests here. Firstly, the circumstances from which an inference of guilt sought to be drawn must be cogently and firmly established. Secondly, those circumstances should be of a definite tendency unerringly pointing towards the guilt of the accused. Thirdly, the circumstances taken cumulatively should form a chain so complete that there is no escape from the conclusion that within all human probability, the crime was committed by the accused and no one else. The Magindran's case also referred to the case of Kishore Chan against state of HP, whereby in this case, K. Ramaswamy Judge said that in cases that rely on circumstantial evidence, the question of whether the prosecution proved the guilt of the appellant beyond all reasonable doubt must be asked. All the circumstances from which the conclusion of the guilt is to be drawn should be fully and cogently established, must be satisfactorily established, and the proof circumstances must bring home the offences to the accused beyond all reasonable doubt. He also added, if any of the circumstances proved in a case are consistent with the innocence of the accused or the chain of continuity of the circumstances is broken, the accused is entitled to the benefit of doubt. Applying to this case, firstly, the circumstances from which an inference of the guilt sought to be drawn must be cogently and firmly established. The inference of guilt can be established since, in fact, the 2 accused persons aggressively attacked the deceased with the weapon. The deceased who ran for his life into the plantation after several minutes was not coming out from the plantation together with the aggressors. He was instead found dead the following morning at the last scene where the accused emerged from. The appellant is arguing on the period of when the deceased was found on the following morning, which may be left to any interference to cause death. The time gap between the deceased to be found within 8 hours is short, and it is not possible for the other perpetrator to go to the oil palm plantation and kill the deceased except for the 2 accused persons. It should be noted that the only evidence produced was all pointing towards the accused person, and there was no additional concrete evidence that can be concluded as the sole cause of death for the deceased. If it was not because of the accused person to cause death to the deceased, then the deceased should get out from the oil palm plantation as soon as the accused persons left him. Moreover, SP2, the police was found that there is no signs to indicate that the deceased was still alive after the accused person left the oil palm plantation. The deceased also should not be lost in the oil palm plantation as the place was near to the deceased house, which makes the deceased familiar with that vicinity. Thus, the period of time the deceased to be found did not affect the evidence produced in point to the accused person to be guilty for murder. Secondly, those circumstances should be of a definite tendency unerringly pointing towards the guilt of the accused person. This was affirmed since there is no escape of the conclusion that the murder was committed by the accused persons. The appellant says that the weapon was not produced, which might affect this case. Even though there was no weapon produced at the scene, it was affirmed by the pathology SP15 that the cause of death was the stab wound to the heart, which depicts the consistency between the investigation result and the argument made by the witnesses saying that both the accused person was attacking the deceased with parang or knife. In addition, according to the argument made by the witnesses, there was nobody with parang and knife except the accused person. Therefore, it is sufficient to point accused person to be guilty for murdering the deceased. Thirdly, the circumstances taken cumulatively should form a chain so complete that there is no escape from the conclusion that within all human probability, the crime was committed by the accused and no one else. There was ample evidence to show the guilt of the accused persons in causing the death of the deceased. It does not matter whether there is a motive or not, since the nature of death was sufficient to make the accused person guilty. In addition, as motive is part of mens rea, it also has been mentioned in the case of Unsung bin Rasad against public prosecutor that the intention to cause death can be disregarded if the intention to cause bodily injury is appears. This can be referred to the arguments made by the witnesses SP6 and SP12 that argued that both the accused person were the one who slashed the victim, which also can be considered to have caused bodily injury to the deceased. Thus, the motive of causing death should not be relevant to be discussed in this case. Moreover, the motive is not the mens rea but only part of mens rea. The fourth element is the bodily injury inflicted onto the deceased was certainly carried out with the intention such bodily injury was established. This referred to the nature of the injury, whereby it was found that the stab wound measured 11 cm deep, which penetrated the underlying subcutaneous tissue and entered the abdominal cavity of the deceased can only mean that there was the intention to cause the resultant bodily injury. That injury also would, in the ordinary course of nature, causing death. Thus, we agreed all the elements of section 300C under the Penal Code were established towards the two accused persons, OKT1 and OKT2. Your Honor, this concludes my argument on the substantive issues. I pass to my counsel. Thank you.
Your Honor, may it please the court, my name is Nurul Syuhada binti Johari, and here I would like to continue to address the third and fourth issue on behalf of the respondent. Your Honor, the third issue here is the issue of the discrepancy of evidence, and the fourth issue here is the issue of the existence of common intention between the first and second appellant. Your Honor, there are two things under the third issue which are first, the discrepancy should not make the witness unliable, and second, the discrepancy in the current case is not vital, hence it should not affect the case. Firstly, the discrepancy of evidence did not render the witness as unreliable. This principle had been produced in the case of Muhammad Alias against public prosecutor, whereby Judge Charles Ho stated that it is open to the court, having observed the demeanor of the witness, and after careful consideration of such discrepancy, to accept parts of witness evidence if it considers them to be true. Your Honor, aside from that, SP6 was very fluent in narrating the incident that happened on the night of 3rd April 2017. He narrated the sequence eloquently and very fluently despite the long interval between the date of hearing and the date of murder occurred. And also, despite the numbers of cross-examination happened during the trial court. Here, SP6 succeed in passing the acid test. As for SP12, Your Honor, his testimony is consistent with SP6, except for the part on who slashed the deceased in front of the latter's house. Besides, the witnesses also had known the two appellants and the deceased since their childhood. Hence, there is no reason for the two witnesses to make any statement in favor of the deceased. Applying this principle to the current case, there is no reason why the court cannot rely nor accept the testification made by the two witnesses, as it had been proven that the two witnesses are credible. Your Honor, the second thing under the third issue is the discrepancy did not vital in the sense that it did not affect the current case. Your Honor, the discrepancy of evidence with regards to who slashed the deceased is a non-vital issue, as it did not alter the fact that the deceased was confronted by the two appellants, which resulted in him to run into the plantation in the course of saving himself. The slashing scene happened before the murder took place. Hence, it did not have relation in determining the identity of the accused person. As this case is related to the issue of common intention, which I will explaining more in catering the fourth issue. Hence, it is immaterial in determining who between these two accused persons who have the mens rea to kill the deceased. Besides that, Your Honor, the fact that the first and second appellant ran into the plum plantation in pursuit of the deceased was not affected nor changed by the discrepancy of the statement made by SP6 and SP12. The contradiction between the two witnesses also did not relate to the fatal injury that caused the death of the deceased. Therefore, there is no doubt that the discrepancy of statement made by SP6 and SP12 is not vital and it should not affect the court in giving the judgment. Your Honor, now I would like to proceed with the last issue, which is there is a common intention between the first and second appellant. In applying Section 34 of the Penal Code, it requires the meeting of mind between the offender as established in the case and others against public prosecutor. Here, if the appellants had common intention to commit a crime, they will be liable for the crime committed in furtherance of the common intention as if they did it individually, as stated in the case of Faraz Bentamure Mhd Rahim against public prosecutor and other appeals. Your Honor, applying the principles and the rules in the current case, the common intention here was very clearly shown by the two appellants upon their arrival in the same car, as soon as they arrived, both of them, while each having a weapon, namely parang and pisau, were looking for the deceased, which then attacked the latter. This scene should be viewed as a whole and not to be assessed in two different situations. Your Honor, the fact that both appellants have weapons with them while the deceased unarmed, and the two appellants chased the deceased to the palm plantation after slashing him, make it even more obvious that they have common intention. Even if one of them, which is one of the two appellants, not only intend to stop the other, it does not matter since there is a common intention between them which make both of them liable for any act made in furtherance of the common intention. Your Honor, even if there were no weapons found at the crime scene or even in both appellants' possession, it does not change the fact that actually the two appellants was armed with weapons in pursuing the deceased as what had been testified by SP6 and SP12. There is no person who would voluntarily expose the crime made by themselves. However, that does not change the fact that they had done the said crime. Besides, the appellants did not dispute the fact that they actually brought weapons in the course of pursuing the deceased to the palm plantation. It is just the weapon was failed to be found by the authorities. Hence, there is no doubt that both appellants brought weapons in the course of attacking the deceased, even if there were no weapons found. The respondent did not have to prove on who between the appellants that caused the injury, which caused the death of the victim, which caused the death of the deceased, as Section 34 of the Penal Code had been invoked. This is in line with the principle which had been produced in the case of Faraz Samurai. Your Honor, to conclude, the learned judge of the previous court did not err in making the judgment as all issues had been addressed fairly and correctly based on sufficient principles of law. As such, the respondent submits that both appellants are guilty for murdering the deceased and the appeal should be dismissed. Thank you.